via som. Teste de áudio.
Bom dia a todas, todos que nos assistem. Vou começar aqui em português, só para dar as boas-vindas. A gente está muito emocionado, porque hoje é o primeiro dia aqui de volta às aulas, volta à escola, e também é o nosso primeiro evento aberto para o público externo, então sejam todas e todos muito bem-vindos. And I would like to thank Joshua very, very much to be Thank you very much. We are looking forward to hear everything that you have to say to us, okay?
And vice versa.
Thank you. Vou passar a palavra aqui para os meus queridíssimos colegas e amigos, os Alexandres, para darem as boas-vindas a todas e todos.
Bom dia a todos, bom dia a todas. É com uma imensa alegria que a gente está aqui para ter um evento na nossa volta às atividades na escola. A gente estava com muita saudade de estar de novo nesse prédio, de poder ter uma discussão interessante e principalmente de ter vocês aqui com a gente, para a gente poder ali ter uma discussão bastante profícua, bastante profunda. And switching to English, and thank you, Joshua, because this is a very important opportunity for us, not only to have our students back, have people back to discuss an important subject, not only AI, but technology in the legal field, I think, in a broader sense. And I would like to thank you very much to be a part of this initiative and to be a part of this moment with us, because we are not only excited, but we are a little bit emotional regarding this specific moment. So thank you very much to be a part of that. Eu vou passar a palavra agora para o Alexandre, também para dar as boas-vindas ao evento.
Bom dia a todos. Grande satisfação a gente iniciar, né, as atividades do ano com esse evento. Nós trabalhamos juntos aqui todos mais de um ano aí na tradução do livro, né, que é o objetivo de a gente estar aqui. É um dos livros mais importantes do mundo relacionados à inteligência artificial e direito e também, obviamente, a prestação de serviços jurídicos, né, o quanto tudo isso tem impactado a nossa vida. O Joshua é um dos pioneiros do mundo nesse assunto, um dos fundadores do Codex da Universidade de Stanford e também fundador do Lex Machina, que é hoje, né, uma das maiores ferramentas do mundo relacionadas ao uso. Ele vai contar um pouco. Então, é uma oportunidade para a gente. Eu vou voltar aqui para o Alexandre, mas ele quer justamente bater um papo, né? Então, incentivar aí todos a já pensarem em suas perguntas. Ele vai fazer uma explanação rápida, mas a ideia é a gente bater um papo e poder, nessa oportunidade, né, entender um pouco de tudo que tem acontecido no mundo, também nos Estados Unidos, e ele também conhecer a nossa realidade. A gente viajou para alguns lugares, né? Ele foi para o Rio, para Brasília e agora aqui em São Paulo também. E agradecer os nossos apoiadores. Aqui estão o Peixoto e Cury, o Matos Filho, também o Pinheiro Neto, o Finoc Ustra e o Urbano Vitalino, né, e o PIG, que são os nossos apoiadores aqui desse projeto. E agradecer a vocês. So, thank you, Joshua, and also thanks, Tammy. Tammy, without you, we'll not be here yet, for sure. So, Joshua, it's a great pleasure to be here. So, it's an important morning for us here at FGV.
Bom dia. What a pleasure to meet with humans, right? Even a few humans, as opposed to online. As much as online has been incredibly efficient, like I think a lot of you, the pandemic has actually made us busier, certainly in the States. Corporate transactions and everything we're doing actually accelerated, so we're very thankful for that, but we really miss meeting humans in person. And so let's take a moment, as I think Professor Marina said, and just appreciate that. Thank you to Alex, Alex Pacheco, Alessandra, and Marina, and Pacheco Curry is here, and all the other law firms, Matas Fiu, Pinheiro Neto, Finocchio Ustra, and I'm missing one. I said that one, yeah, Pichetto Curry. Thank you so much for making this possible. We had actually come here, we were scheduled to come here 2 years ago. I'm not sure, I think in March.
Exactly, it's the day that everything was closed. So you're going to arrive on March 17th.
Yes. So literally, this is a flash forward of 2 years. You can kind of hyper accelerate through it. When we first came here, it was an amazing trip to see the culture here, right? Sao Paulo is a very unique culture. This trip we went to Rio and Brasilia as well. But as I was telling some of the law partners here, Brazil has a really unique community, right? It's Brazilian culture. So I'm not going to suggest there's a samba to the legal tech here, but I think there is a samba to the legal tech here. You should, and I'm going to change the title of today's talk a little bit, which hopefully is more of a conversation and less of a talk, if you'd be open to sharing some ideas and questions with us, despite the fact that we may not have met before. It's on Brazilian legal AI. And the reason I use that term versus generic legal AI is a lot of legal AI simply does not work if you transport it from France or from the US or the UK and you drop it into firms here. It doesn't work. The Portuguese language itself, Brazilian Portuguese, is going to present unique natural language processing issues. That's one. Number two, the legal lexicon is different. Right? Just the court structure is the fact that there's a constitutional court with a unique jurisdiction set, there's the STJ, right, with a different Supreme Court, that and the military courts, civil courts, tax courts, just the way that these things are broken out is actually radically different than our structure in the US. We have a lot in common, right? So you can think of all the things you can leverage that are, language models, as well as linguistic things and methodologies and infrastructure. So leverage everything, but understand everything is also entropy. Everything you do here is going to require some unique work, unique legal thinking, as well as some of the language adaptation in what you're doing. And it's got to be samba, right? So I'll start today a little bit with a few definitions of terms. I know Marina and probably both Alexes will have some questions that we'll start off with. But if you can think of your own, I would much rather, because we have a chance to meet in person now, talk a little less and listen a little more. Yes. Oh, sorry. The only way to shut up a lawyer is to cut off their mic. So I was trying to help. But I'll bear in mind that there are other people out there. So. And then if there are questions, we can either hand around the mic or I can repeat them too, whatever's more efficient for you. So I'm going to start by defining some terms of art. And we do this, as you probably know, or as you're going to learn if you're a really early student. One of the first things we typically do in an M&A agreement or a legal document that's transactional is define terms. So there's a few I'll go over. One is law. The second is engineering. The third is legal engineering. So we're getting fancy pretty quickly, but these should be pretty simple. I'm also going to define AI. So pardon if you've heard this before, but there's so many definitions of AI that are floating around. I think it's helpful to define something simply. The caveat to this is most of these definitions are ones I've just made up. And you should attack them and challenge them, and hopefully others will as well. Particularly in the technical definitions, I've created them as an attorney, as a humanities person, not an engineer, not a computer scientist, because the linguistic definitions I see of these technical terms are terrible. They just don't make any sense. The English word for a lot of them, or I would call it gobbledygook, right? So. I'm trying to interpret them as a lawyer, and hopefully the engineers and the technical specialists can tell me where I'm wrong and improve our base definition. So that's the caveat. I'm going to define them anyway, and we can talk about it. The other definitions, and we talked a little bit today with Alex Pacheco in the car, as well as some of the partners from Pichetto Curry about cities and environments and how you build an ecosystem. So I'm going to define the word legal architecture, or at least suggest that that's a thing. Legal architecture. The other one is legal infrastructure. I think that's particularly important. It's particularly important as our countries go through political turmoil, which is just a reality right now that we've got to deal with, right? How do you define infrastructure and how do you make the law part of that without dehumanizing it and turning it into concrete, if you will? And then I'm going to talk about legal subsystems. The last definition I'll give is legal innovation. Again, a word that's used a lot, used so much that perhaps we haven't given it credence yet, and I'm going to try to turn that into a formula. Probably fail, but as we know in Silicon Valley, the one thing in Silicon Valley that's really, really unique is we try things and we fail, not when the client is on the line, but when we can do something in an experimental environment and then improve it. And it's the failure that teaches us how to do it right, right? It's the struggle that actually produces the good outcomes. Okay, I would define law as the art of regulating human behavior, state, and relationships. Human behavior, state, and relationships. Welcome. How do you say welcome in Portuguese? Bem-vinda. Bem-vinda. Obrigado. My vocabulary is picking up the longer I spend. And it really helps to stay in. When we went to the Marriott later this week, and I was very disappointed because there were way too many gringos there. So I love my country, but it's nice to be amongst Brazilians too. Bem-vinda. Sorry? Is it okay to demask? Okay, all right. I'm vaccinated and tested negative, by the way, for the record. That's another interesting thing that's happened is there's an entirely new etiquette for COVID now. It's different in different countries, and it's a balance between politeness and safety, and we don't have a lexicon for that yet, right? We're creating it as we speak. So law is the art of regulating human behavior, state, and relations. Behavior seems simple. People shouldn't murder each other. You shouldn't steal. How do you treat each other with respect in a way that's protected by the law, right? Essentially, do unto others, right? That's pretty simple. State, I would call is, what do you owe someone else? Is someone guilty? Do they have, are they innocent, right? Are they a citizen? Are they not? Are they someone who is a visitor like me? How do you define their state? And then relations are both relations to people as well as relations to things, property, chattel, all of that. Seems kind of obvious, but when you define it that way, all of a sudden legal has computational science relevance. And one of the things we found at Stanford, which was back in a day when computer scientists avoided lawyers like the plague, and some of them still do, but not anymore, really. There's been a sea change, or a fundamental change, about the interests of computer scientists and engineers in the law. It is fundamentally different than it was. But back in the day, nobody wanted to touch this. Venture capitalists wanted nothing to do with us. It was a kind of a dead zone in a lot of ways. And if you start defining law in computational terms, two things happen. One, it gets very dangerous, because you can dehumanize justice, right? Things like that. You can make them think that law is just data, like any other kind of data. Not correct either. We'll talk about that. But they are, all of a sudden, there's this vast weight of computational knowledge. 50 to 300 years, depending on how you define software, computer science, back to Gottfried Leibniz, right, in Central Europe back in the day. That entire weight, that power of operationalized math becomes useful in the legal domain. It's an entire universe. And while I, as a lawyer, very, very much a lawyer, whether I want to be or not, I'm very different than, say, MBAs. A lot of MBAs think very differently, I would say. We think very, very similarly to computer scientists. So from an academic perspective, I would say that law is actually, it's not just aligned with computer science. I would argue it's the same thing. And I'm sure someone will say it's not, and it would be a great discussion. So I'm happy to have that discussion. The reason to say it's the same, lawyers, like to argue. The reason I would say it's the same thing is computer science is seized with two things: procedures and classification. And again, there's a long discussion of this in the book on legal AI, which is in Brazilian Portuguese, thanks to Alex, Marina and Alex, and the sponsors of this program. So it's there and it's out there. And the book is way better than anything I could say here today, but we can talk about it live. Computer science, though, is procedures and classifications. Classifications, that's what lawyers do. Is this person classified as owing tax? If you structure the merger this way, you're going to owe this kind of tax. If you structure it that way, it's that kind of tax. I mean, tax is a huge practice area in Brazil in particular. Here are the disputes. And the procedures for determining what happens with those if there's argument, it's a procedure. You can think of the court system, not literally, but in a modeling kind of way, as an algorithm. A discrete system of steps that are very particular, right? They're set in federal codes, they're set in state codes, and in the domains of electoral law and tax law and all these things. You can see them as a set of states, and all of a sudden, for the first time in history, we have the data. Brazil more than most. 83 million cases live right now, according to last week. I think it was 83 million. 90% of that data is available in some form. So you have a set of procedures. Again, we have all these things as lawyers. It takes an enormous amount of review time to go through them and understand what's happening, which is, again, it wasn't a computer, it was me sitting in a basement, right, reading every single case in my particular domain at one point. It's going to be you or your associates at some point, and you're going to be combining it with financial data, with insurance data, with risk data. But we had all that data. The entire weight of all computer science can help us model this, if we're humble enough. And we'll talk about that in a bit too, because as much as there are technical definitions here, I want to give you a few, call them poems, call them memes, call them thoughts, that are useful benchmarks, whatever you're doing in this area. So that's law. Law is the art of regulating human behavior, state, and relations. Engineering, and I want to stress here, no engineer will actually agree with this. I just made it up. But engineering is the art of getting things done. I owe this definition a little bit to the then president of Stanford, John, I forget his last name. He's the chairman of the Google board of directors right now, small Silicon Valley community. And we were launching this company called Lex Machina. Again, stories in the book. Feel free to find us on LinkedIn. We're all there. We'd love to chat with you about what you're doing and help, right, with real things. But we were launching this company, and the president of Stanford had these grand programs for Stanford, what it was going to do. And it was engineering and something, and biology and computer science. It was a few great things. And I said, law should be one of your great standards. There's an enormous amount of value we can bring to society if you choose law as one of the great, standards for missions of the university. He goes, lawyers don't get things done. And I hope he doesn't mind me quoting him, but it was meaningful. And I said, well, what about this lawyer? She's an incredible lawyer. She's on your board of trustees. She does X, Y, Z. And he goes, but she's an exception. So engineers sometimes get the wrong things done. They're not always up to standard, which is the life and death issue. So they're not perfect. Sometimes they're arrogant, like us, in our own way. But engineering is the art of getting things done. And again, as a lawyer, law to me is first, helping people is first. Everything else is kind of secondary in a way to the legal state and the relationships and doing my job at the best possible level I can do. But one of the critiques we get as lawyers, and one of the things that limits us, is that we don't do things in a scalable way all the time, or we say no because that's the position we're put in. In the book, we talk about the 7 steps to software annihilation, right? And it's basically what typically happens in a Silicon Valley startup. Napster is a good example. There were lots of great innovations there. You build the thing, you launch it, it goes out there to 100 million people, and then there's this huge issue like copyright law. All of a sudden, you just determine it's illegal. Everything explodes in a ball of fire. The consumers are left with the old way of doing things, which they're never going to go back to. The record companies, in the case of Napster, they're staying with the old ways of selling albums and CD-ROMs when the technology has moved on and consumers have moved on. And the whole economy in this domain sinks and just craters. Music is finally coming back. But that's typically what happens. You have this great innovation that's technical. They keep the lawyers away from it because lawyers, they're like zombies, right, as one of my judge professors used to say. They walk around killing everything they touch, right? So you avoid the lawyers, and then everything explodes because they're doing something that's fundamentally not going to work or that is theft, right? If you're Metallica, you don't want all of your albums free, and you're not going to make more albums unless there's an exchange, right? And it's kind of a golden rule kind of way. So what we're suggesting in the book is to take the lawyer and insert her at time zero. Camouflage her as a member of an engineering team, or the product team, or the financial innovation team, whatever it is that, could be making potato chips. Put her in at time zero, so she's part of the designing and architecture team. And that's where I get the word legal architecture. Lawyers at time zero. That's a better way to do things. Because at the end, things are already out there. They're not going to change it because they're making tons of money and they're now a unicorn with billions and billions of dollars. It's too late to say yes to something intelligent from a legal architecture perspective. And so we're put in this position where we're like, no, you can't do this. But if you're there at time zero, it's a very, very different scene, and the ability to make more intelligent choices from a legal perspective is much, much lower. So engineering is the art of getting things done. Legal engineering is the art of getting legal things done and things done legally. Legal engineering is the art of getting legal things done and things done legally. Another professor that I like to quote a lot named Frank Easterbrook, who is one of the toughest, the curmudgeonly judge who's always out there and just brutal with people's briefs and things like that. He was the epitome of that. Even other judges and professors, they noticed he had this propensity to be very, very blunt. And back when he was writing, and I think this is a reading in Professor Marina's course, back when he was writing, cyber law became a big, big practice area, and it became a practice area for a lot of us. And Judge Easterbrook said, there is no such thing as cyber law. There's only the law. There's the law, and there's how we apply it to new technologies, right? Which is a reasonable way to think about it. And he said cyber law is like law of the horse, or horse law. So I like to cite this and say, we're interested in horse law. We're very interested in this, actually. And we think that horses or cyber or the scale of digitization actually makes a difference, as in Napster, to the nature of the law. At some point, quantity is a quality of all its own. So the speed of these transactions in Napster actually changed the law. The law didn't change, but because of the scale, you're not just giving a cassette tape to your friends or an 8-track to your buddies at work. You're sharing your record with 8 million people like that. And that fundamentally can change it. So there's horse law, which is interesting. A lot of what we're doing, though, is horsepower. It's applying law and this entire body of computer science and law to the things we're doing on a daily basis. M&A, litigation, tax law, the things you're doing today. Not some abstract thing we're going to build in the future, though we can do that too. That's what universities are for. That's what R&D departments are for. But it's the things we do every day to make them better, faster, cheaper, to help the clients more. So when I say that legal engineering is the art of getting legal things done and things done legally, we're actually applying these things to do the same things we're doing every day. I'll give you a very simple example. When we were doing M&A deals, I was a lawyer for a firm called Simpson Thacher in Silicon Valley. And I would look up, I would do a Google search on past deals that other people had done, that I was against. So if company X had sold 3 or 4 of its divisions, I would look at those deals, and if they were material, which they often were, I could see the deal terms in the public filings, right? It was a treasure trove. And one time, this very famous IP lawyer said to me, we're not going to give you this trademark term. We don't do that. And I looked up online, and the last 3 deals, he had given this trademark grant to all the other buyers. And I said, hey, Bob, you did this last 3 deals. You should give it to us too. End of discussion, right? We got that. Client is much better off. They got something of fundamental value. Just because we did a Google search. We're doing the same thing in litigation, just with a lot of AI and at a greater scale, by building a SaaS tool, a dashboard for all US federal litigation and now increasingly all state. And one of the important things about being able to build these platforms is, as Brazil is doing and struggling with, is, again, economies of scale. Lawyers like me typically will sit in as a 1st or 2nd year associate. Everything we do, someone's going to lose $1 billion reals or $1 billion if we mess up the signature page on a document. So it's very, very important, but very simple in a way. So, or we write a brief, and yes, it's used by other people, it's referenced, they might read it, but we do it once, and it's used once. And it could be the best litigation brief in the world, but it's never really used again, not given the amount of volume that put into it. Software is fundamentally different. It's a fixed cost, low marginal cost structure. You have to invest a lot of money, there's an enormous amount of risk, you may fail entirely, but if you succeed, you may dominate the market with your piece of legal software. Because it solves the problem and it can solve it for everyone. And this giant fixed cost investment costs a lot, but each use by another user doesn't cost essentially 0. And adding it to another domain costs very little as well. So when we built an algorithm for patent law 1 million years ago to find patent law events, it also works for admiralty law and securities law, and it scales to the state law things as well. So again, those economies of scale, that weight of that software, which we really customized, right? We took the best in the state of the art of AI, and we did something incredibly customized with it, with lawyers and computer scientists sitting in a basement together. But that's horsepower. Artificial intelligence is a term you come up. And by the way, any questions so far, Marina, Alex? I'm going to be calling on you constantly because you probably call on your students a lot. So, yeah, please.
Oh, perfect. My question is regarding cultural issues when we are trying to put together in the same room lawyers and engineers. Because the first thing that I would say it would be difficult is how can we create a way to them to communicate with each other? This is the first thing that struck my mind, because usually when you have a mindset that says to you that you need to get things done, it is difficult because usually you need to, for example, you rush things to launch your product or your service. You pressure, for example, your colleague, your fellow colleague that would be a lawyer to get things done. So one of the things is, how can we create an environment that will actually make these two very different professionals to work together? And a second thing that I would like to add to this question, it is, do you think that if we create environment spaces in a law firm that we invite, for example, tech professionals or engineers to be a part of a law firm, to help them to change their mindset regarding their professionals, the way that they do things, this could be one way to change the culture regarding lawyers? Because usually when I think about a law firm, usually the first thing that comes to my mind, it is wood. It is
Sorry, what was it?
Wood, like, yeah, I don't know, because a lot of law firms that I visit, are made of wood. They are very traditional. They are very serious. They usually have large meeting rooms, so on and so forth. So one of the things that I will think regarding that is it possible to have a more collaborative environment regarding a law firm, have different faces in a law firm? Because for me, when you say, when you define legal architecture and legal engineering, for me, one of the barriers would be, one of the obstacles would be culture. We are trained to think in a way that will not be a part of the way that engineers think. But that's my question for you, the cultural obstacle that we have to actually create legal engineering.
That's great. And there are essentially three questions there that Professor Pacheco asked. One is about tradition, and what is the role of tradition in legal AI and legal technology. The second is culture. How do you change the cultures? And number three is, you know, how do you get the engineers working with and lawyers working together? There's big barriers there, and there are. So you asked. Let me start with the first question first. You asked a theoretical question about the communication between law and computer science. I'm going to give you a procedural answer. I think you should start a lab here focused on real life outcomes, and I would mix it up. I would mix it up pure social, helping prisoners, helping the poorest of the poor, and helping you know, elite commercial deals. I would do both, and there's reasons for that I'll go into in a bit. I think you should start a lab and just do it. And it's really, really, really hard. There is no easy way to do this, but I'll say this again. Don't start with something where there's a deadline next week, right? If you're doing something that's launching in the public markets, that has a different standard of care for that. And as with surgeons, you're not going to go into surgery with something that's untested. You have to go into something great. The universities in Brazil in particular, as well as in the US, are in a unique position. And FJV is in a unique position because of its nature and history and its speed. Like Stanford, right? It can move at a certain rate. Start a lab and do it. Computer scientists are very similar to us, but it's still hard. And we did a project called, it was the Stanford Intellectual Property Exchange, and it was designed for people that have little bits of content that they could sell them to you know, media organizations, right? And it was YouTube before YouTube. And we were going to work with all the big media organizations, Hulu and NBC and Sony and all that. And it was complicated for political reasons, I think. But one of the things we did, it was a class workshop, mostly a lot of international students in it. A lot of people from computer scientists showed up. And if you think it's hard teaching copyright law or patent law to a first-year student, try teaching it to a computer. Computers are very fast and they're very cheap, and we are neither, right? But they're still very dumb. So you have to, it's very, very hard to teach copyright law to a computer. And criminal law even more so, right? You can't, but in the process of that struggle will teach you copyright law better than anything else. As you know, there's an expression in English that says, if you want to learn something, teach a class on it. That terror will drive you to try to master it. The fear of embarrassment, all those things. But try teaching it to a computer pedagogically. Even if you fail, it's extraordinarily useful. And that failure is valuable, right? If you go to a pharmaceutical or biologics lab, you know, which are resound in Brazil as well as in Silicon Valley, the whole Bay Area, the failures are some of the most valuable trade secrets and data in the world. You may find that habeas corpus in Brazil just doesn't work with these computational methods, NLP, whatever, or the way that prisoners write is different and is going to be harder to do than, you know, than partners at law firms, right, anywhere in the world. So you're going to find places of failure and you'll find places of success. Whatever we find will be unexpected. You know, there's an expression I use. It's one of the poems I mentioned. The beginning of wisdom is the fear of God. What I mean by that, you don't have to be religious to get this and use this. The set of things we don't know will always vastly exceed the set of things we do know. Everything is entropy. It's really, really hard. There's always chaos between us and success from a client perspective. But if we start with that perspective, it'll go through. And I'm gonna take that thought and go to a definition in a second. The other points you made are really important. And I have a debate with my team. They like to say hashtag change or change the world, and I think that's great. But as an empiricist, I'm not pro-change. As an empiricist, I'm pro-utility. How can I help my client? Whether my client is the dead, you know, if it's a war crimes tribunal, whether it's a big corporation, whether it's a prisoner, whether it's a citizen, you know, a citizen X, right? Whoever she is, I have to value my innovation and my technology by that standard. Is it helping this person or not, right? Maybe it helps me a little bit, but that should be a small percentage of them I help them, even if we're on an hours basis. It's got to help them. And the clients notice this. They know when they've gotten massive value for something. So if my standard for ROI or return on investment is how much am I helping something, tradition, culture don't matter. My tradition, my culture is the duty of loyalty to my client. So if I have a way of helping them, I have to do it. Part of the way I'm helping them is through tradition. The tradition of the law, we were with a lot of judges over the last few weeks, magistrates in Rio and then in Brasilia. The traditions they have are very valuable to Brazil. The way they select the presidents of the courts, the way they give their library books when they've passed away, these traditions offer enormous value to the comity and the collegiality of things. In the public markets, the way that people interact, the traditions of these verses and things, they're actually very valuable. So we don't have to be anti-change or anti-legal culture. We just have to be loyal to our clients. And that's how I define legal innovation. One of the big dangers we have in law firms is that there's a lot of pressure from the clients. We want to do legal innovation things. We want to learn. We are learning machines as lawyers. And this is a great place to learn constantly. Not just in intellectual property, but in trusts and estates. There's an enormous amount we can learn. So when we do that, the thing that drives us has to be helping someone. And we will help them using logic software. We will help them using statistical software. It doesn't matter. We have to move the needle. And if we can't, it's not a change. So a lot of law firms in the US, they'll have a legal innovation person, and he or she is sitting alone in a room, and they're doing some projects, and they get some press from it, and that's it. It does not affect the way they do work on a daily basis, because that's really hard. It doesn't affect, and universities can do things in a way that's much faster, and they can test things before, you know, someone's in legal surgery, if you will. So I define legal innovation as this. RP2 is greater than RP1. The ROI to my client for procedure 2 is higher than it is for the existing status quo. Maybe I need to be more traditional, not less. But that's how I define legal innovation, and that's how I deal with culture. I love the culture. We're not anti, we're not pro-change, but we are, our duty, our loyalty, our tradition is to help clients, not help ourselves first. Did I answer any of your question?
Yeah, definitely.
Thank you.
Do you have a...
Yeah, please.
So, Jay, so we went to Brasilia, our Supreme Court, and also to CNJ, and we saw the automation and the data science jobs they are doing. They decreased 50% the time of a lawsuit. So it's amazing, 50%. How's the impact of that in the life of the society, on the economy, and all of that? So now we are seeing the same movement for advisor or strategic legal service in Brazil, using no-code or low-code solution, etc. So how do you think it's the next steps? How the law firms have to look at that as a tendency, and how they're going to do to absorb and use what we are learning with our lawsuits system management for this kind of jobs?
That's a great question, and it reminds me of another great question that Alex Pacheco had asked. So the two Alexes are the twin pillars of this, with Marina as the central node. Now, I think everyone is, and especially... that's profoundly true. Sometimes our physical environments alter or improve or reflect our theoretical ones. It's a joy to work with everyone. One of the issues we have to solve is financing. How does a law firm pay for an R&D lab? In the US, and I believe the same is here, they're all LLPs or LLC, they're partnerships. So if you invest $1, it's pro rata 1 cent from one of the 100 partners' pocket. And she may or may not be happy about that, and legitimately so, right? Obrigado. This is another thing to watch out for. Always look around you before you step back in a technology project, because everything is entropy. No, you're great. Again, financing for law firms is a solvable problem. The big four accounting firms and consulting firms, they're eating an enormous amount of legal work, from LGDP compliance to GDPR compliance to contract review, and they're able to do that because they use contract AI, right? So their junior associate, even though he or she is not trained in law, is reviewing 8 times as many contracts as they could before this. And that's literally true. It's 8 times. They're still a human. They're doing exactly the same thing, but they're using a statistical tool to accelerate that times 8. It finds the privacy clauses. It maps them out. We start to identify problems. So you actually can't not use this tool, but how do you finance it? And I think, you know, one of the things legal AI has taken off, thank God. So I've started my own firm, but before I was doing that, right, as a solo practitioner of legal AI, I was working for a giant insurance firm. And one of the things we could do is create financing solutions for law firms that would do, you could use your intellectual property as an asset to borrow money against. So if your IP was worth $1 billion or $1 billion reals, you could borrow 500 million reals from that. Other people, there's actually, using the tools of contracting, law firms can act more like the big consulting firms because they can create special entities and all that. So I don't think the financing problem is a real problem. It's just one that we have to attack. Law firms can create startups, right? There's a lot of options for doing that internally and externally, as long as they understand the economics of software, and that, you know, being part of the best thing in the world is actually going to be cheaper and better, faster, going to help them do better for that. I don't think, not every law firm has to create a software unit. You can actually just keep doing what you're doing or be part of platforms to do these things. So there's a number of different solutions, but I want to flag the finance problem. Alex had asked about what the judges are doing. I think as these things scaled out, there's going to be all kinds of problems in litigation, and maybe, are we doing them as well, right? We're doing them faster, but are we doing them as well? For me, again, the reason to use these types of things is because if we don't, my competitors are using it. So if I don't, my competitors are going to beat me. The judges are using it, so I can't appear before a judge and know less than she knows. That's a disaster. And I won't get the work unless I've done the empirical research beforehand. So Alex, again, I don't know if you asked about no code, low code. Did that?
So as we are learning how our judiciary is doing about customer experience, but we can see each phase of the legal, the lawsuits and the documents and etc. So how we're going to use that on the advisory or strategic legal service.
Yeah. I'll share one anecdote and then we'll keep going. I was in front of a very famous arbitrator when I was a young entrepreneur, and he goes, "Why do I need data? I don't need data." He had just won one of the biggest cases in the history of arbitration, right, involving a large consulting firm, we'll say. So he said, "I don't need this," right? He was a top guy. And I said, "It's not data, it's history. And if we don't know the history, we're doomed to repeat it." In the US, you can see patterns like this judge in East Texas only grants summary judgment orders using this doctrine. He denies everything else. These 200 summary judgment orders, he's denied them all except on this one legal doctrine. So if you're going to waste $500,000 on all the other doctrines, there's an argument that you're not legally competent. You have to say, we're going to focus on this doctrine for summary judgment, this phase of the case. And client, we could do these other arguments, but they're likely to, again, here's the history. You may want to do something different, but you need to know that you're running against the tide. The other way that the judges are using this is they're going to say, hopefully, they don't have to decide, 1,000 constitutional law cases or 10,000 constitutional law cases on the same exact issue. They can find the issue, decide one or a set of them, and then the precedent will flow down. What I haven't seen them using yet here is the empirical data about, hey, this process improves the outcome of cases, it gets to settlement faster, all of that. And the lawyers can use this to say, here are the outcomes that are possible in front of this judge. She may do something different, but it's risky. So knowing that data, it should get us closer to settlement. The other thing that we found, and sorry for talking too much, is when you interpret the words in a patent, it's called a Markman order in the US. And it doesn't matter that it's in patent law, it could be in anything. When you interpret the words in the patent that's in dispute, in a patent infringement case, the likelihood of settlement goes up by 50%. Immediately. Some judges have this interpretive event late in the case, some have it early. Late in the case because it's hard to do, it's very technical, and most of the judges are not engineers or scientists or biologists. So the court system found this out, and they said more judges started using this event sooner. So it improved the overall efficiency of the system better. When we did, and the last comment I'll make on this is, and again, this is a multi-day discussion about how you use empirical data in litigation. We found that Congress had asked the Comptroller General of the US about a certain type of plaintiff and a certain type of lawsuit. We got the job, we had to fight for it, right? It was very hard to get, but we got this job that we lost money on as a academic-y kind of startup. And we found that Congress is wrong, the legislature is wrong. This thing that people talk about, this mythology, it's a phantom. There's no such thing as this evil type of plaintiff. It's a spectrum of different types of plaintiffs, and it's kind of a mess. We did find that the executive branch was giving these certifications in a way that they were being struck down 95% of the time by the federal court system. So the judges were kind of the correction system or the error control for the executive branch, president's branch, and we're just wasting hundreds of billions of dollars a year on stupid lawsuits. That is really powerful, and then the system can correct itself. And that data went back to the courts, it went back to the White House, it went back to the Senate. And between all three of them, which were fighting to try to get it done first, because they want credit for it, right? The egos work in favor of correcting the system with empirical data, as opposed to being divergent and factional. The system corrected. The Supreme Court corrected the issue. Maybe they're too much, right? We have got to figure that out. Maybe we can't do enough of this procedure. But the system was able to correct itself. And the most important thing about empirical data is before we had it, it was almost like people were trying to rearrange the furniture in the dark. The lobbyists were doing one thing and another, and the law firms were doing X and Y and Z. With the data, and we had to fight to show that we didn't care what the law was. I have no religion about patent law. I don't care. It's what works for the system, what works for, individuals. If you can prove that this empirical data is just data, it's like turning the lights on in the living room. And you can say, oh, the couch is here, so objectively, we don't want the couch blocking the kitchen, right? Let's sit it against the wall. Not everyone's happy with that, but it's better for most people most of the time. So that empirical data can be an antidote to faction, which is one of the biggest problems we have in all these countries. Sorry, it's a huge question you asked, but hopefully went to it a little bit. I wanted to talk a little bit about infrastructure, subsystems, and access to justice and artificial intelligence. So we'll start with artificial intelligence. I would define artificial intelligence as software that automates analysis. That's it. And we can argue about it. It's kind of a marketing term now. I would say it's not about action. It's not about sensing things. It's about analysis. So let's make it less fancy, and that will help us a lot. It's essentially using data and operationalized math. I talk a lot about legal infrastructure and legal subsystems in the book on legal AI. Legal infrastructure, again, we're not talking about concrete. This is complex stuff. It's not. Hopefully, it's more concrete when the lawyers write it than it's not. So it's not loosey-goosey, but it's not concrete and it's not a commodity. But we need to think about our legal and judicial systems in the same way we think about the highways and the roads and buildings. And it's part of the environment people live in. They just can't see it. And it has to be funded that way, too. So some things the courts will do, some things the lawyers will do, but some of this has to be funded. If you're going to have something for this general citizen, you've got to think about it as kind of national infrastructure. The other thing I would say is that I was a flying car lawyer for a little while. I've done probably always the same thing, but sometimes in different environments. I was working for a company called Airbus and was very fortunate to be, when I say flying car lawyer, I don't mean I was a flying lawyer that specialized in car law. We did, like Embraer is doing, we had things that are like giant drones that are going to fly themselves. So instead of helicopters in Sao Paulo, you're going to see a lot of drones that are a little quieter. There'll be air traffic control that's a little more robust. And that's a subject for another day. But one of the things I advocated as a lawyer at Time Zero is that we should have legal subsystems. So you have an entire system that's designed to be used by the engineering team for all the law stuff, from privacy law to zoning to the time of landing. And that legal stuff is infinitely complicated. We're not going to resolve everything. We're going to resolve a lot of it. So let's create a structure for that complexity, and let's have a language for lawyers to talk to engineers through that. And that's something you have to build, Professor Alex. It's not going to be built on its own. And it has to be Brazilian, Portuguese, legal language, and legal subsystems. So anyway, let's keep going with questions. Yeah. Great.
Eu queria só, se alguém também tiver pergunta, gente, fiquem à vontade, tá? Joshua, maybe this is not exactly the time, but I really would like to hear what do you think about the deregulation of profession, because without this technology, I think many things will change, especially in an environment that we have here in Brazil more than 1 million lawyers, and how it's gonna, what's gonna happen in this situation. And Alex, please.
I was very interested regarding your argument about funding, especially because here in Brazil we have a rule, if I may say like that only lawyers could be partners in law firms. So you need to actually try to get funded by lawyers to do things that lawyers do throughout the law firm. So one of the things, and it's a main challenge here in Brazil, is how do you convince lawyers to fund a lab or a research and development department in their law firms? Because they will usually say that, oh, we are paying for that, and we are not seeing the results in a short-term period. And one of the things usually we do is to ask them, oh, we should change the regulation for the legal profession. And
no problem.
No problem, exactly. But we have a lot of difficulties to convince them that would be better, and we actually give them examples regarding other countries that allows to get funding from different types of professionals, different types of entities. For example, we can ask for a VC to actually invest and get some equity regarding a law firm. So just one quick question to actually add Marina's question. What do you think, what will be the importance of changing the funding structure for law firms to invest in technology in law firms? Because for me, it's not only about technology, but it's also about funding. Because when we think about companies that innovate, they usually, one thing that they should do is to convince the people that will invest in them that they have a good idea, they know how to implement, and they will get good results. Here, if you are a lawyer, what are your options?
Yeah, great questions, and they loop to each other as well. Behind you. There you go. And again, thank you so much. Obrigado. Two quick stories, because these are impossible questions to answer this morning, but they're easy questions to start to answer. When we started Codex at Stanford, again, and this was people thought we were nuts. Like, this was not oh, great idea. This was, people thought we were insane. Some of the most prestigious professors in the world have called me nuts, and it was a great privilege. And again, they're right in their way, right? It's just, you can start something and just do it, and you will make progress, and it has its own momentum. So either everything will stop you or nothing will. You can start with nothing, and sometimes that actually is a powerful thing that will draw other people. Codex, the first funding wasn't us. It was a student that said, I want to be a fellow at your school to do that. He just graduated from the law school. He got it, and he'd finished his clerkship with a judge. He said, I want to do this. He convinced a company to pay him $50,000 to be a fellow for a year. And he spent no money. Like, he lived in Silicon Valley, which is a very expensive place, and he was able to do that. And then the second or third year, one of my colleagues convinced the dean and said, hey, we should make this a regular thing. And now it's a fellowship that's ongoing. So sometimes the prototype you have to build in your garage with nothing, and that's okay. So don't let anything stop you, one. The second story is I was appointed to something called the Access to Justice Task Force in California. And in California, lawyers service about, it's probably 0.5%, but a half a percentage of the actual legal demand in California is actually met by lawyers. About a half a percent is my estimate. The survey data suggests that it's less than 5%, but there's an enormous, and then 80% is the people that actually report, say, I need this and I didn't get it. It's the poor and it's the rich. It's everyone in California. None of them have access to justice. And that's one of the reasons I don't define this in my lexicon. There is no access to justice anywhere. Lawyers are covering a tiny, tiny fraction of the market for need. And what do I mean by this? Even at the top companies in the world, they're just kind of blundering through a dark thicket of law. They don't see things. They don't have their employees, even if they have great product counsel, they're not able to understand or address the legal navigation that they should actually be doing in an ideal state. So we are servicing a tiny proportion of the market, and there's an enormous suffering and amount of death caused just in California by the dysfunction and corruption we have, by lawyers that are litigating in ways that are very vexatious or very inefficient, that need to be regulated better, by judges that are corrupt. We have enormous problems just in California with access to justice and the efficacy of the entire system. So the reality is, but in this case, despite that, people were terrified of using AI. They're terrified of consulting and accounting companies buying law firms and just taking over the planet, which is a legitimate concern. And what happened was they tried, there's a specific rule, it's 5.4, 5.4b, and it's state regulated, where the bar is a state governmental agency, effectively, not just a membership organization. So there was a huge amount of backlash that said, don't change the rule on non-lawyer ownership. And they said, if you do that, we've had a lot of problems with immigration. They're called notorios in California, and it's people that describe themselves as paralegals or as experts they sell their services to people that may not be able to afford a lawyer, or that aren't necessarily, they're new to the country, they don't speak English, they need help, they're going to get thrown out, and they get bad legal advice, and horrific things happen. Families are torn apart through bad legal advice. It's like surgeons operating in a bazaar, you can imagine. So they're saying if you have non-lawyer ownership, this problem is going to spike enormously. We said the bar can't regulate bad lawyer behavior today. We have enormous corruption, inefficiency. We have lawyers that are protecting themselves, not their clients, creating disputes where none really exist. So if you want to regulate better, you need to let, for instance, you could let a law firm go public and take 4% and use it for programs for the poor. That's a good transaction. The Supreme Court advocate, who's part of this bar committee, said, well, what if you've got Samsung and Microsoft in a dispute, and then Samsung buys 51% of the law firm representing Microsoft. So there's conflicts issues from that are non-trivial, and there are big problems with it. But we won the dispute in the Board of Trustees. There was a big fight over that exact rule. And we had the two top people who were the trustees of the organization who said, this is going to be bad, and we shouldn't mess with non-lawyer ownership. Then another person spoke up, and he was an immigrant. He's from Mexico originally. And he said, I've been through horrors. My family has been through horrors. And if there's a way to carefully, in a well-regulated environment, help people who are in need, we have to do it. We're actually ethically obligated to do it. And it was the vote was like 12-2 in favor of exploring it. We're still very careful. What's happening in the US, in 2 states we have rules called a legal sandbox. We'll talk more about that in a bit. But they're able to license individual entities. It's very carefully regulated. And people like LegalZoom or in Arizona, consumer-oriented, are doing it. So if you regulate it well, you can start to address the 95% of the market. I just think there is an enormous amount of death and destruction that's happening in all these legal systems. And I don't just mean criminal law. I mean the family law systems in California and other states of the US, they kill people. A lot of them are predatory, they're broken, we can't see what's going on in them. And having empirical data, like Alex talked about, is the first step. For elite, like big companies, they don't know what they're doing half the time. They're blundering through and triggering billions of reals of damage without, that they don't need to. And the systems are often very inefficient too. So being able to use and look at this data, it costs money. It takes a lot of work to take the raw data, almost like raw iron ore from the ground, and turn it into a flying car, right? Which is what we really are talking about. And every one of these AIs is different. None of them is working perfectly yet. How do you pay for the work to do these things? The lawyers, the engineers, the computer scientists, the policymakers, the design people. The question is, how do you pay for the work? There's no easy answers to that, but I would say that our duties as lawyers, both to improve the system and to help people, require us to be doing this. Other questions? Sorry, lawyers talk too much, so please stop me.
In this effort for us to put together the right resources to move forward with this challenge, I'm more leaning towards in this question, the transactional work advisory side rather than litigation, because this is my area of practice, but feel free to answer for both perspectives if there is any difference. I'm just wondering, because I kind of almost hear through your speech that we got to think a little more outside the box in terms of the right teams for this. I'm sure it's not going to be just lawyers anymore in the office. So I am now going through an experience of putting together a team of lawyers to do a quite challenging process of transforming the way we do things. And we got together the best consultants possible. And this is fascinating and kind of scary at the same time, because I'm learning that for some things that the consultants could actually do the work better than the lawyers, because they know better how to manage these new technologies that we are trying to apply to our lives. But I know, and I was very intrigued by your comment when you said, okay, you know, engineers, computer scientists, they get stuff done, but not necessarily the right way.
Yes.
So I was just trying to, you know, put all this together and understand how do you see the law firms in the future? Do you really see them with multidisciplinary teams working all together? And this is going to be a big challenge also with our Corporação de Ofício, OAB. You know, the Bar Association in Brazil, it's very old school. And the changes there happen very slowly. And I'm sure we're going to face challenges because now we just had, you know, fights in very recent past about other companies that not legal advisors trying to do part of the work that we do. And the big four companies are on the top of the list, of course. So maybe they got the right solution already because they are more open. They are not so heavily regulated as we are. But we got to do something about it. So we have to work with the regulators. So we need to be allowed to bring these people in and compete, you know, as heavily as we will have to do if we want to survive. But then there's also the internal challenge of how we make lawyers work with non-lawyers. And I just would like to hear a little bit of your thoughts about this.
Those are great questions, and there's about 5 dimensions to that. I'll start with training, but they're great, and they're exactly what we need to talk about, and we need to talk about what goes wrong in all these things. For the big four, you're right. They're very agile. They're moving very quickly. They fund startups. They'll buy a startup for $200,000 in India and then scale it to their every single area of tax to whatever. So they're very agile, very fast. And again, law firms still are doing well, right? There's a lot of activity. I mean, we looked at an M&A boom during the pandemic, and there's a lot of suffering. But you know, that piece of the digital world actually accelerated. You had like 3 times as many meetings and business development things happening in my experience in that world. So there's a weird set of incentives. The big four have problems too, though. They're partnerships, and they're very political, and they're fractured by country. So I think if you're a startup, you would ask yourself, what do I do better than anyone else in the world? What can I do that's really unique, that's mine? And I think as a starting point, I would say that Pacheco Curry's data, intellectual property, and talent pool is unique. And like many firms, every AI is unique, every data set is unique, the traditions are unique. You have unique powers, and you start there. You don't need to say, let's disappear. So in the book on legal AI, we cite, there was a historical event, and I was criticized for mentioning this. What does this have to do with law and innovation? But in Japan, in I think, gosh, the 1800s or so, Japan had been a closed society for a very long time. And all of a sudden, these American, literally metal gunboats showed up on their shores and say, hi, you're open for trade. And so the shogun, like everything changed. And there were a lot of people in Japan at that time that said, let's throw out our traditions, let's dress like Westerners, forget about samurai and all this. They would just ignore it and be Americans, right? And that was kind of a disaster. I mean, there was something good to it, but another group in Japan said, and it was called the Meiji Restoration, right, where the emperor got more power than the shogun all of a sudden. And it was a hybrid of Western technology with the traditions of Japan, and it was very powerful. I think that technological transition is the most successful I've ever seen in any bit of history that I'm aware of. And it was a hybrid. It was not, let's throw things out and let's start from scratch. It's like, what are our strengths? And Japan changed technologically incredibly rapidly and incredibly successfully, and they were way ahead of a lot of Russia and other places. What happened later was not the same thing. So what I would say is start with your traditions, start with what makes you unique and your unique legal knowledge. Your AI is going to reflect that. But get the best in the world in terms of the other stuff. The training that lawyers get should include use of empirical data, the ability to talk to other professions. A lot of the work that I've done has been translating legal artifacts, right? Taking a very complicated legal thing. It could be a lease, it could be a contract, it could be a patent or 20,000 patents, and translating that into dollars, into finance. This company is worth $200 million more than its peers because of their intellectual property assets, their data assets, their leases, right? Their certifications from the government. So translating certain things into finance and operations can totally transform the legal landscape and how much lawyers are valued and what they're paid to do. But it requires an expert's view of the data set. So just again, one example, and pardon me if you don't care about IP, it's not important in the legal domain, but it's an example. We created something called Quality of Intellectual Property Report. When you buy a company, there will almost always be a quality of earnings report. And it tells you if you've got one buyer of your services who is about to go bankrupt, right? So they're very not great revenues, right? Or you've got 20 million clients and they're based everywhere and they're very diverse and they renew their things. So it's the quality of the revenue. We did the same thing for intellectual property assets. And we said, here are the trade secrets, the data, the know-how of the humans that makes this company unique. And that's now part of a lot of M&A deals in the US and overseas. We're using this, and it's making a difference to the M&A process. But it takes a lot of AI, it takes a lot of specialists, and at the end of the day, it was me and one other guy, an investment banker. You know, a lawyer and an investment banker walked into a bar, and out walks QIP. We're writing 80 pages of prose in these reports. It's got graphics, it's got AI, it's got data, but at the end of the day, it's reading and writing. And how do we take something incredibly complicated and make it simple so that an investment banker buyer or a CFO or a CEO, she can read this in 15 minutes and get the gist. And bam. I'll give you one more example. We had a biologics company that was really, really complicated to understand. And we started off this report by saying, biology is messy. Microbiology is very chaotic when you try to do it in real life. You go to an oil well or you go to a gas station and you try to sample things. It's very complicated. So that set the stage for why this company was valuable, because it had a lot of experience doing very complicated analyses of COVID and other things. So translating things is a really, really important skill set, but it requires you to be the most expert on the legal part too. Last story, and we can. There's probably a few aspects of your question I'd love to keep going on if we have time. When I was in college, I did a multidisciplinary degree because I was interested in a real life problem that was happening when I was in college, and but I wonder, like, am I studying nothing by trying to study a few different disciplines? And my advisor said something very wise to me. He said, some people work on the patches of the quilt, and some people work on knitting the patches together. So in the States, we have these quilts that are made. There's the patch that's beautifully done, and it's knitted together, and sometimes you have 200 people working on a big quilt, or 50 people, and they knit it together. And there's value to both. If you have attorneys that just want to do tax law, or they just want to do family law or criminal law in a very, very niche area, they're technicians, great. Let them be nerds, let them do what they do. If you have people that like to put things together and are like, know how to talk to consultants and technology people who will steal your wallet if you're not careful, right? You have to be very careful of consulting firms. You get those people. So I don't think there's a real answer to your question. What I would say is you can hire more diversely as people have in the past. Some people are salespeople. Some people get the work done. Some people prevent all these like alpha nerds from killing each other if they're locked in a room for 48 hours, right? You need all these different personalities to make the ecosystem work. And I think that's always been true of law firms. This is another skill set that's going to be valuable. And when I was a first or second year law student, I made diagrams for an employment law issue. And it was a big manufacturing company based in South America. And they had this HR issue. And so I made a diagram. I said, here are the issues with this. And my partner was like, what are you doing? Like, are you crazy? So, and again, I don't know if she sent it to the client or not. Another time I made a formula that the client loved, and that was, it was very useful to them, but I was careful with it, right? So it wasn't exaggerating. Another time we were doing a patent lawsuit for a giant database company, and I made a database because we needed a database to track some of the different precedent and prior art for us. I got in trouble for that. So sometimes I think we have to be open to that, but it hasn't changed what we're doing. It just accelerates us. It makes us better what we're already doing. It's not changing the landscape. So happy to address more parts of that question. Marina, how are we on time? Yeah. Okay.
AI represents many challenges in the application, like bias, for example. So, what are the limits for AI in law, and where should we apply AI in law, and when we we shouldn't? Thank you.
Great questions. And if I can go back.
Joshua, I'm sorry, just a minute. We just have to thank Ana Silveira too, because she was one of the most important people of our project too. So just before you say that.
Of course.
Just to let everyone know that she worked with us.
Yes. Thank you so much. I bet a round of applause. Thank you so much. And it'll be easier when we have no masks too. So to see people. I'll go back to horse law and horsepower. So horse law is the law of AI, how we regulate AI, and horsepower is using it to get faster and more cycles in our engines. I think lawyers have a special duty to regulate AI and artificial intelligence. I don't think anyone else is set up to do it. I don't think consultants are. Consultants and tax people, they don't care about that. They take a course and they say, I can do law. I do all of it. And again, we know that lack of humility is dangerous and blows things up. Like the Enron, right, is the big risk that we're all thinking about in the US. That was driven by an accounting firm that no longer exists because they didn't follow the ethical requirements on self-dealing. So that's the other end of the Scylla and Charybdis between innovation, right, to bad innovation and stasis, right? Cell death is the other risk, right? We don't do anything on the other hand. And when and Pachetto Curry had asked about the bar regulations as well. I'd like to address that too quickly after this question. Lawyers have a special duty to regulate AI and to work with teams to do that internally and to build the legal subsystems internally. Again, very controversial, and I love the work that's actually being done in this area, but I don't think most of it's real. There's a term called ethical AI that's used a lot. It's used a lot by a lot of big engineering firms and big companies. And in my view, I love the idea of that. I love the idea of AI being ethical, but I think it is a red herring for the most part. Red herring mean it's designed to say, hey, look, we're taking care of this, but it means nothing at the end of the day. It's a false lead. I think lawyers are specially trained to deal with these kinds of things, these engineering and ethical and bias problems. This is what we do. And it's a huge growth area for firms. And students, I mean, this is regulating AI, what happens to it. It's going to massively expand as a business area, not just for business, but for regular citizens. So we have a special duty, and defining that, creating a legal subsystem that's going to doing that is uniquely attuned for that. What I told the judges, there is a decree that's written by the CNJ that says, all AI we use shall be unbiased. And what I've said, and that's wonderful, that's great, but what I've said is, there is no such thing. All AI is biased, all humans are biased, 100% of us all the time. And this is something that social psychologists have figured out and determined, in clinical settings, we are naturally biased. We are naturally prejudiced. We naturally make generalizations. Lawyers are trained to undo that, to say, this is a citizen, I'm not going to judge them by the color of their skin or what they're doing or their neighborhood. I'm going to treat them in this legal structured way, and you can train an AI to do that better than anyone else. And we know that we're biased too, so we need other lawyers to help us. We have to do it in a way that's non-destructive, that lets the engineers actually do what they do, and that helps people at billions of transactions a day. But the lawyers should be engineering that. The legal engineers should be involved in that. They don't have to be fully accredited lawyers. They can also be students from other areas that have had appropriate training. You can have different types of people. But I think all AI is biased. I think all humans are biased. And AI, what is it? It's just data and operationalized mathematics, logic, statistics. Our data, because it comes from us, is biased. So literally the chatbots that are created using open data, they're all prejudiced, right? And the teenagers take them and manipulate them, right? That's going to keep happening. You know it's going to keep happening. You as a lawyer can predict it. So you have a special duty to go in the engineering room when it's being designed and say, hey, this is how we're going to test this, and we're going to have, when you have AI, like a convolutional neural network in there, you don't know necessarily why it's making a decision it's making. So you have to cross-test it. You have to take other AIs and challenge it, right? Just as you would lawyers in a courtroom. So it's a profound question. What I would say is, again, beginning of wisdom of the fear is the fear of God. We know that everything will be biased. We have to create anti-biased or modulation systems that reduce the amount of bias as a goal to get to unbiased that we'll never reach. Last question was, Pacheco Curry asked about the challenges of looking at bar regulations and how do you make a change. And it is terrifying. Like there's no question that it's a challenging question, and the Enron risk exists. Consultants take over and lawyers can't fulfill their ethical duties. The CEO of a company steals money essentially from shareholders is exactly what happens. And we know that's going to happen. It's going to happen in every case. So how do you deal with that Enron risk? The other risk is cell death. There's a risk of stasis. And it's not as if we're doing, we have things perfectly and we're going to do something risky. We're already doing something risky. People are dying because we're not doing our jobs at the scale that legal engineering would allow us to do it. So you have to balance those twin risks, the Enron risk with the risk of cell death, and they are both extant. The patient's going to die unless we do something extraordinary to move things ahead. And I think keeping those twin risks in mind is the way I like to think about it.
Bom, passa muito rápido o tempo junto, mas a gente quer aproveitar um pouco, convidar todos também para tomar um coffee com a gente. I would like to say thank you so much, Joshua, for the book, for all the talk and all the visits that you did in Brazil. And I wish you can come again very soon. And thank you all for being here. Ale, querem falar alguma coisa?
Obrigado.
Só agradecer. Just thank you so much to be a part of this initiative. I think for us it was wonderful to hear from you, especially when you try to incentivize projects here, try to push forward something that we usually think among ourselves, should we try it? Should we do it? And this not only an idea, but this force that you gave us to motivate us throughout the process, especially after this kind of period, it's amazing. And I would like to thank everyone to be that is here. and that is interested in this subject to be a part of a large community that we are trying to build here in Brazil to discuss all of these subjects, to try to qualify the public discussion regarding that. And I think Joshua proved us that we have a full agenda in front of us. We have a lot of issues that we need to discuss. So thank you to be a part of this, and thank to start the conversation that we needed to move forward regarding AI and other subjects regarding law and tech. Thank you very much. And
Can I say one quick
yeah, for sure.
before I hand it off to Alex? You are not alone. So we've been through this, we've suffered through this. I've been the lawyer with the AI, and I've been the AI guy. And so you are not alone, and it's an honor to be here. Thank you so much, all of you, for the privilege.
Yes, this is our privilege, and we just have to thank you again for all your time that you're spending with us, and hope we can even give you the examples that we are doing here, and I hope to it's also been a good moment for you to let this message from Brazil too, that we have this kind of judiciary, we have this kind of people, and we are working on the technology to support us in the most important thing. It's to give access to justice, to have a better society. So that's what we're doing here together. And thank you again. And it's a privilege for me to be here at CEPI, FGV. We are working together for the last at least 5 years, but at the 2 last years, I became formally a member of CEPI. So this is the first presential event that I'm here as a CEPI research member. So thank you very much, Marina and Alexandre, to have me here with you.